Morning everyone, how's everybody this morning? How are you feeling? Thinking about the A team? Are you putting on a face today? Are you a little bit Mad Murdoch? Are you not getting on no plane? Whatever you're feeling today, whatever your challenges are today, one thing to bear in mind this morning, you've made it through, you're starting a new day, and I'm sure whatever challenges today throws up, you're just going to completely smash them out the park, just like you have been doing so far. So welcome back to the third instalment now of my employment tribunal journey, and today I'm going to be talking about what followed my protected conversation, which I covered in the last video. So today we're going to be talking about without prejudice. So for the people who saw my last video, on the 10th of June 2020, I received a call out of the blue from my manager asking me to enter into a protected conversation. And following that conversation, I received an email that was titled "Without Prejudice, Subject to Contract." Now, obviously, at the time, I had absolutely no clue what that meant. Didn't really pay much attention to it, if I'm honest. And basically, the email contained a summary of the conversation that we'd had earlier. So it covered the fact that the company were not in the greatest position. They were looking to cut 2-day full-time equivalent, or 16 hours, which matched my working pattern. And that was from the administration department. He reiterated how they were offering me £1,000 if I volunteered to take voluntary redundancy, and also reiterated the fact that if I refused the offer, then the company regretted to inform me that based on the scoring criteria that they'd already carried out, I would be made redundant. It then went on to show 6 different criteria that the company had selected, 3 of which were probably classed as quite standard. So there was length of service on there, sickness absence and disciplinary action, all of which I scored really highly because I'd been there over 10 years. I think I'd had 1 day off sick in the time that was measured, and I'd had absolutely no issues or disciplinary actions in that. And if you're going through a redundancy consultation, you'll find that generally those 3 things are kind of standard things to measure people against. They are measurable, they are impartial, they should be able to be backed up with your work record so that you can check those figures. The next 3 boxes were based on performance, and what the company had done is they had basically worked out what they deemed to be an important part of the administration role, and they specifically related the next 3 scoring criteria on tasks that were done in the admin department. So it showed everybody on there, so there were 6 of us involved. So each of the tables for each of the scoring had all 6 names, and basically what they did was the company had decided that the scoring matrix they were going to use was going to be done from 0 to 5. So basically if you received 0, then that was because you'd had a lot of sickness absence, for example, you'd had, your length of service wasn't as long as other people, and so on, up to 5 being the highest. So if you scored highly in one of the sections, then you would receive 5 points, and basically at the end it was totaled up, and the person who scored the least was the one that was likely to be made redundant. So just before I go any further, the important thing to point out here is that at this stage, as far as I was told, and it's pretty clear now that it was the case, that no other members of staff, certainly in the administration department, knew anything about what was happening. The Without Prejudice email that I received stated quite specifically that I had to keep everything confidential. I could discuss it with my family, and if I wanted to, I could take independent legal advice. But it did state that if any of the other administration team members found out about the voluntary redundancy offer that they'd made to me, then they would withdraw it. So other than the conversation, 20 minutes, half an hour before I received this without prejudice email, there'd been no warning of redundancy, nobody had been consulted, nobody had been brought up to speed, we'd not been shown any form of redundancy plan or anything like that. No discussions had taken place regarding the criteria that should be used. No discussion had taken place to decide the scoring matrix and what people thought were measurable and impartial and fair. And I wanted to point that out as we went along because it really was quite a key area in my final hearing about the fact that the scoring and the criteria were done before anybody knew about the redundancy consultation. They were presented to me and I could clearly see that I'd scored the lowest. And in the next video, I'm going to be talking about when the consultation started and how everybody else was then given the same tables as I'd been given, and they could see themselves at the top, and they could see that I'd scored the least and I was at the bottom and most likely to be made redundant. And that's a really key factor. And they are really relevant, but I will come back to that in a later video. So back to the email that was marked without prejudice, I was told that should I refuse the offer of voluntary redundancy, then the company would undertake a consultation process. But they'd done things in this way, so i.e. asked me to enter into a protected conversation, told me to keep it confidential, offered me £1,000 to take voluntary redundancy and basically just go quite quickly and quite quietly. And they said that the reason they'd done that was to minimise the stress not only on me, but also on the rest of the team. Now, obviously, looking back now, number one, that was a complete joke in itself, because whilst it may have worked very well for the company and also very well for my colleagues in the rest of the administration department, it certainly didn't minimise the stress on me, because obviously, you know, I'd been called out of the blue. I'd been basically told you either take this money or you're going to lose your job anyway. As I've previously said, you know, my partner was self-employed. My wage was the only stable wage coming in to support our 2 young children. So, you know, that really should have been a red flag for me, because the fact that they were telling me not to tell anybody and kind of threatening that, you know, if anybody else finds out about this, you know, if you do tell any of your team members, then this offer's just going to be totally off the table. And that was a bit naughty. They also went on to say in the email that they didn't want me to think that anything had been prejudged, because, again, looking back now that I'm, you know, much more, you know, forearmed with information, I should have again seen this as a huge red flag with flashing lights on, because for them to say at the start that nothing's been prejudged generally means that it probably was. And in my case, it certainly was. So, yeah, but obviously, you know, that's the reason why I want to make these videos, because if I can give somebody else the benefit of hindsight, then it may, you know, just save somebody else going through what was just a horrible experience. They also mentioned in the without prejudice email that they didn't think that I'd been through a process like this before, so they thought that it would be helpful to put this information in writing. So obviously they knew that I had absolutely no clue what I was talking about. I'd never been through a redundancy process before. I had absolutely no idea on protected conversations, voluntary redundancies, without prejudice communication. And I do feel personally that the company used that completely against me, and they did work that completely to their favour. So this is why I always say to people, forewarned is definitely forearmed. So when these things crop up, don't rely on your employer, because even though you may think that they'll continue their duty of care towards you to the end, if they do have a prejudged and a predetermined outcome, they will only guide you in the process in as much as from their side to achieve the outcome that they want to achieve. Following on from the protected conversation and the without prejudice email, I think I covered this last time, that they gave me 7 days to consider their offer. ACAS does recommend between 7 and 10 days, But unfortunately, if a company are making less than 20 people redundant, there are no actual guidelines for them to follow. So, basically the time that they give you to consider any form of settlement offer or settlement agreement or negotiation really is down to your individual situation. So, depending on the offer, depending on, what the offer includes, will really determine how long the Employment Tribunal think was a reasonable amount of time for the company to give you. So obviously I'd had the protected conversation, I'd received the without prejudice email. To put it really bluntly, I was just an absolute mess. I think it was on the Tuesday that I'd received the call and the email. By the Thursday, I had made an appointment with my GP. I couldn't sleep. I was just being sick. It was just awful because I felt like I literally was damned if I did or I was damned if I didn't, because I felt that I either had to accept their offer, which would mean that I was out of work, which was just awful to start with. But obviously we were going through the COVID pandemic. I was asthmatic, so I was at that time classed as vulnerable. I didn't know where else I was going to get a job. My partner, as I say, was self-employed. I knew we would have no regular income because he didn't have any work at that time. And my other alternative was to turn the offer down, but then I would have to go back into work and face all of my team members, knowing that a redundancy consultation was going to be launched and they would all be given these figures with me at the bottom. And I would go through all that humiliation because some people in my team I'd actually, I'd trained them. Because as I've mentioned, when I was full-time, I was a team leader. I set up the administration department along with my team. So it was I was absolutely mortified to learn that somehow my scoring and my performance had put me at the bottom of the chart, because there were people there who'd only been there just over 2 years. And I thought, how? I just don't understand how I've come below everybody. So as I say, I was absolutely beside myself. My mind was just racing at 100 miles an hour. And every day just seemed to be ticking really quickly. And I was aware that the 7 days were nearly up and I had to make a decision. And I was back and forth, and I really didn't know what to do. And me and my partner were just up till all hours, just, if I accept it, what about this? If I don't accept it, what about that? Day 6, I received a missed call and then received another call from my manager, basically chasing me up, saying did I need him to repeat what he'd said, was I clear on the offer. He wanted to reiterate again that I would get an additional £1,000 if I just took voluntary redundancy. And I just said to him, I was just a bit shell-shocked, and I just said, I'll put something in writing to you because I don't know. I didn't know. And I did put something in writing to him later on, and I did decide that obviously I didn't want to just put myself out of a job. I genuinely didn't think that I was going to be out of a job. It was just a bit crazy. It was just crazy times anyway. And I genuinely didn't think at that point that they would do that to me. I thought, it's 16 hours for goodness sake, and you employ, so many people and there's so many job roles. So I wrote back to them and said that I didn't want to accept their offer, but I was willing to work with the company and basically, work towards a resolve that worked for both of us, not just worked for them, because, after 10 years and just putting me out of a job, I just didn't think was right. I didn't think it was fair. And if I'm honest, I just really didn't think if I had the chance to speak to them and speak to other people, that it would come to that. I received an email back pretty quickly from the manager saying that he didn't know what I meant when I said that I was willing to work with them to find a resolve. And he just wanted to be clear and reiterate again that if I didn't take the money now, they certainly weren't going to offer me any more money, and it would just be a consultation, and that would be that. And, you know, it wasn't about the money for me. I didn't want to ask them for more redundancy money because I didn't want to be made redundant. You know, I wanted to work something out so that I could keep my job. And again, we're going to get into that in the next video, because that's the consultation. Because shortly after I just declined the offer again, I received another email a few days later to say that the manager was going to be launching a consultation process with the rest of the administration team, and obviously the outcome would be the outcome. But the reason that I just wanted to make this video and kind of just make a video about that one email is because, as I said earlier, at the time I didn't realise what without prejudice communication was. So I had absolutely no idea, a little bit like the protected conversation, that you cannot use anything that's genuinely marked without prejudice in an employment tribunal as evidence. So a protected conversation is not submissible for an unfair dismissal claim, but you can use evidence about a protected conversation in other claims throughout the employment tribunal. But without prejudice has full protection across the board. So not only can you not use it in an unfair dismissal claim, you can't use it in any other claim either. So because this had taken place, I had to go through a preliminary hearing, which allowed the judge to determine if I could use the without prejudice communication as evidence in my case. Because after starting the tribunal process, or going through ACAS, when it came to preparing my ET1 form, I'd done some research on protected conversations and without prejudice, and I learned that there were exceptions to the without prejudice rule. So what I've done is I've put together a slide which I'm going to post after this video, and that covers what without prejudice is, how it differs from protected conversations, and the reasons why sometimes, and it pretty much does come down to a judge's discretion, but sometimes why without prejudice communication can actually be overruled by the judge and it can be submitted as evidence. Now, luckily for me, the judge saw things from my side, and other than the unfair dismissal, it was ruled in my preliminary hearing that I could use the without prejudice communication for any other claim that I raised through the employment tribunal. Now, an important thing to remember is you must bring any without prejudice conversations, any protected conversations, you must highlight them at the beginning, because if you don't include them in your initial ET1, then the courts don't know that they exist, and it's literally like you're going to be bringing in new evidence at a later date. I'm going to be covering more about completing ET1s and the pitfalls of them again in a later video. But in relation to without prejudice, what I did was when I completed my ET1, I filled in all the sections about what had happened, the protected conversation, the without prejudice protection, and their solicitor actually objected to it in their grounds of resistance. So that's how it was brought to light with the employment tribunal, and that's how come it led to a preliminary hearing about it. Again, I'll do about preliminary hearings in a later video because they are quite common nowadays, but I have actually put the link to my judgment for the preliminary hearing just in the description. So if anybody's going through an issue of without prejudice, then you can read my judgment, you can read my written reasons, and the judge actually deemed in my case that what the company had done was, because without prejudice relies on the fact that there's an existing dispute for it to have coverage, they'd actually created a dispute just minutes before. So thanks for watching. I'll be back soon. Bye.